A living will is basically a declaration by a person saying, in the event that they're terminally ill or have severe dementia or in an irreversible coma, that they do not want to be kept alive by artificial means once that determination is made. It actually is typically done in conjunction, at least under Illinois law, in conjunction with a healthcare power of attorney. And it's kind of interesting. In the old days, before the statutes implemented the healthcare power, the first attempt at addressing this issue was the living will. And basically the living will is a declaration from myself as an individual to my medical provider that I don't want to be kept alive under certain circumstances. And that worked for a while, but some issues came up with it, and so the states passed different statutes, and you now are allowed to appoint an individual or a doctor or whomever to act as your agent to make that determination on your behalf. Some of the problems that happen is periodically the person you've picked to be your agent when the situation actually arises doesn't have the ability to go ahead and actually tell the medical providers to remove your life-sustaining procedures that are going on. And so you're in this quandary of, if your agent doesn't act on your behalf, then what? So if you appoint your spouse, for example, to be your agent under Illinois law, and your spouse chooses to just not act effectively, if you've decided you don't want to be kept alive under those circumstances, the medical people are going to continue to give you treatment and keep you alive because your agent isn't telling them otherwise. The living will actually still works hand in hand with the healthcare power, in that if your agent is unavailable or unwilling to make that decision for you, the living will is your declaration to the world, and specifically to your medical providers, that you don't want to be kept alive under very specific circumstances. We still use living wills in those cases where people indicate in the healthcare power that their preference is not to be kept alive under those serious circumstances. We actually modified the plans in my office after the Terry Schiavo decision, and we made them more specific to include provisions dealing with the withholding of a feeding tube and hydration, which was the specific issue in her case, to make sure that, you know, we give our clients much more of the certainty that they're looking for when we work on this.